All right. Our topic for this video is updatable contracts. Let's first remember where we are. So we're still on looking at offline contracting. Excuse me, that's our background to our consideration of online contracting. We've covered 4 doctrines so far, and we now have our remaining doctrine of updatable contracts. Let's start with a case that illustrates what the topic is. Right, so this is Purdue versus Crocker Citizens National Bank. So background, Purdue had a checking account with with Crocker National Bank for a number of years. And during that time, on a number of occasions, the bank raised the fee for processing checks drawn on accounts without sufficient funds. Now, to understand what's going on, you have to know something about paper checks and the accounts that use them. I assume that you don't use paper checks. The United States is actually one of the last remaining places where they're in common use. But in 1986, they were the way in which people drew money out of their accounts and paid their bills. And so you wrote a paper check and either gave it to a business where you're buying something or paid your bills with it. And it took a while. Back in 86, I think it would be about 7 days at least for the bank to process the paper check. So there would be about 3 to 7, maybe 10 days before the money in the check you wrote came out of your account. So this raised the possibility of writing checks for more money than you had in your account. Those are the checks drawn on accounts without sufficient funds. The banks don't want you to do this, and it is, by the way, illegal. The banks don't want you to do this, so if you did it and the check came in and you didn't have enough money, they charged a fee for that. And they, depending on your relationship with the bank, they might or might not actually honor the check and pay it, and then ask you to put the money in your account to cover it. But if they had doubts about your relationship with the bank, was it good? They'd just send the check back and not process it and pay it. So that's what the case is about, right? So Purdue has this account for a number of years, and over the years, the banks raised the fee they charge for checks written on accounts without enough money in the account to actually cover the amount in the check. So Purdue's claim is that you can't do that, right? His claim is that when he opened his account with the bank, the fees were one number, and that's the amount he agreed to when he opened his account. And so he and the bank are in a contract that says that shall be the fee. And he says, well, look, since we're in a contract that says that will be the fee, they can't just on their side unilaterally, on their side alone, decide to raise the fee, right, without my consenting to that raise, because after all, they're bound in the contract where the fee is what it is, right? That's the claim, and that's the claim you see quoting from the court summary that gets down here. Let's get a little bit of drawing here. That gets down here. There we go. Down. That's the court summarizing what we just said. So again, another summary out of the terms of the court. So on the slide so you can see it. So opened his checking account. Purdue claims that's an offer. When he opened his checking account, offer subject to certain conditions, and one of those being the fee at the time it was open for insufficient funds. So more technically, Purdue's claim is, look, I walked into the bank, they made me an offer. The offer was checking account subject to a lot of conditions I agreed to, but one of the conditions the bank and I and the bank agreed to was that the fee for insufficient funds will be so-and-so, right? The fee at the time it opened. And his claim is, since we have a contract, the bank can't unilaterally just on its own change that fee. Let's clean up our slides just so we can focus on what's important here. There we go. And so the fundamental claim is this one down here. Look, since we have a contract, the bank can't change that fee. And that seems sensible, right? Here I like to use, let's get our, there we go. Now here I like to illustrate Purdue's claim. I like to use a relationship example. It seems the clearest, right? Suppose that Alice promises Bob that she will be faithful to him. They're in a relationship, and they say, well, we're not going to see anybody else. And Alice says, I'll be faithful to you. And Bob says, well, and I'll be faithful to you too, right? And then a couple of years later, Bob decides, well, hey, Alice, I'm going to change the content of the promise I made, and I'll be faithful to you, except once a year I get to have an affair with somebody else. Alice said, Bob, you can't do that, right? We promise, and then you can't just decide that you'll change the rules for you on your own, right? We all understand that. That's Purdue's argument. And it seems like a good argument, and indeed good enough that one prestigious federal circuit in the United States has adopted this argument. So in this case, we're going to jump ahead to 2007, although this is actually an online contracting case, but it is a court accepting and endorsing the argument we just made. So we'll look at Douglas versus Talk America, and then we'll go back to the Purdue case, because the Douglas, our relationship argument may be right about relationships, but the Douglas versus Talk America case that endorses that argument in the case of contracts is just clearly wrong. And the Purdue court is clearly right when they say, yes, the bank can change the fees unilaterally. So let's see what's going on. And let's start with the argument against the change in Douglas versus Talk America, because it looks good, but our task is to look more deeply and see, gee, what's exactly wrong with that argument. So Douglas versus Talk America, I quoted from the case so that you'd have it in the slides, but let's give a verbal summary. Talk America purchased America Online's long distance service. Back even into the turn of the century, 2000s, America Online was a major internet service provider in the United States, probably more in the 1990s. It was one of the big internet service providers, and at one time it had a long distance service too. It had a long distance telephone service. America Online, fortunes declined, and as it was selling off parts of its business, it sold off its long distance service to another company called Talk America, right? So that's the background. Joe Douglas had a contract with America Online for long distance service, and when America Online, the long distance service, was purchased by Talk America assumed that contract with Douglas as the successor in business to America Online. Then, when Talk America acquired the business, it changed the contract. You can see, and it made a number of changes noted in the slide right there, but the one that we'll focus on is additional service charges. It raised its fees. Bottom line, Talk America bought America Online's long distance service and then raised the amount that it charges for long distance. Douglas noticed that, and he says what Purdue says, hey, you can't change the amount I pay for long distance because I agreed to the amount when I contracted with America Online, and that contract still contract is still in force against you as the successor in business of America Online. We have a contract. You can't just say, and now we'll pay more for your long distance service. right? Unless you can do that, but only if I agree to it, and the court agrees, right? The court says the revised contract is merely an offer and does not bind the parties until it is accepted. Just what we would think about Bob, right? Bob says, hey, Alice, but from now on, I get to have one affair a year. And that in contract terms is an offer that doesn't bind Alice until Alice says yes, right? That's what in technical contract terms we would think. Right, so the court concludes, gee, a party can't unilaterally change the terms of a contract. It must obtain the other party's consent before doing so. And our question is that true? And Purdue shows it is not, but it sure looks true. It sure looks true, right? Because what's the point of contracting? The point of contracting is you promise, I promise, right? We each promise, and the idea is we each commit to abiding and by keeping our promises in the future, not changing our minds, right? And the only way we can get out of that commitment is to go to the other one and say, will you agree to call it off? That's what's behind the Douglas versus Talk America Court's claim. So why is it wrong? Why is it wrong? Because you can put the right to make unilateral changes in the offer itself. Let's do this in two steps. Let's first see that's what the bank did, and then let's see why that makes a difference. Right? That's what the bank did. As the bank explains, look, when Purdue came in to open his account, he signed what was called the signature card. This was very common in, it's 1986. I did this even in 1998 97, 98, when I opened my first banking checking account in Chicago. I went into the banks and I went to open a checking account, and oh yes, we signed various forms, and among them is the signature card. What's called the signature card looks like a little postage card, and the idea is you sign your name to the card, and then when you write checks and sign them, they will match the signature on the check to the signature on the card. By the way, they never do. I mean, the people used to sign Mickey Mouse and Superman, and the checks would go right through. But that was the idea. But for this case, that card also, in the case of Purdue and Crocker National Bank, contained terms and conditions. It was not just a signature card. It presented terms of the contract. As the court said, in extremely small 6-point type, the signature card states that the undersigned depositors, Purdue, agree with Crocker National Bank and with each other that this account and all deposits therein shall be subject to all applicable laws to the bank's present and future rules, regulations, and conditions. And the court interprets the and future rules and regulations as an offer to open account and give the bank the unilateral right to make changes in the future. Unilateral right. So the agreement is banking services, that's what the bank offers, and Purdue says, yes, and I agree to abide by those conditions in exchange for banking services, including giving you the unilateral right to make changes. So it's not, so this is the bank's point. It's not entering a new contract. When the bank makes changes, it's not creating a new offer to enter a new contract. There is no offer to enter a new contract. They're just exercising a right they have under the existing contract. So since they put the right to make changes in the offer itself, right? The Purdue court, the Douglas court is just wrong about this. They're wrong because the bank's answer is there was no sorry about that. There was no revised contract. No revised new contract. No revised new contract. No, when we made the changes, that wasn't a revised new contract we proposed as an offer. That was just exercising a right under the existing contract. And that is what the Purdue court says is right. The court agrees. And indeed, the courts that have considered this, apart from Douglas versus Talk America, have agreed. This was a fairly well-established precedent in the commercial retail banking cases. It's just surprising that Douglas versus Talk America court missed this, but Purdue is right. Douglas is wrong. The trick is, if you put it in the right to make unilateral changes in the offer, you're not, in making the change, proposing a new offer for it to enter a new contract. You're just exercising a right that you have unilaterally, have the unilateral right to exercise in the old contract. Why? Okay, so now the important, and this plays a critical role in online contracting, and the important question for us both in offline contracting and online contracting is, why would a bank or contracting party want to do this? So they can do it, but why would you want to? And the answer is, the bank's in a long-term relationship with the consumer, with the account holder. Right? That long-term relationship means that the bank will need to change the terms of the contract from time to time. They may have a need to change fees. Economic situations have changed, cost has changed, right? They may need to raise their fees in response to long-term economic trends. They may need to comply with new regulations. A very good example is know your customer regulations that have been imposed on banks because of concerns about security and money laundering. And they may need to change their fees to respond to market competition. Maybe other banks or other financial services are offering different kinds of services for different kinds of fees, and they need to change what they do and what they charge to keep up with market competition. This may very well happen with the increase in electronic banking and in the increase in use of encrypted currencies. So the long-term relationships create the need for changes in contracts, and this solution has been, well, put the unilateral right to make changes into the contract, into the offer itself. So doing this avoids a situation you very much would not want if you were a business. Imagine you couldn't do this. Imagine Talk America, the Talk America case, the Douglas versus Talk America case was right. Then businesses would be in this very difficult situation. They'd start out at one time. So everybody, like, when Purdue goes in, the bank starts out, everybody gets the same contract. Then with their new customers, later on with new customers, we have some new customers and we really need a different contractual relationship with them. So with the new customers that come in some point after Purdue, they have this contract, but they have to continue this one with Purdue and the old customers. And this just happens again and again. If you're in a long-term relationship with consumers and you change your contracting terms in response to new conditions as conditions change, and you can't change it for everybody, right? You can't make changes in the existing contracts, then you end up with a bunch of different contracts for different customers at different times, and that's just a business nightmare, as you have to keep track of all these different contractual relations and different sets of obligations and conditions. Businesses don't want to do that, and the updatable contract is the solution. But if you can do it, there still have to be some limits, right? There have to be some limits on what you can do in an updatable contract. Otherwise, there is no agreement, right? This is the part we were right. When we said earlier in the Alice Bob example, you can't do this. This is the part we were right about. You can't just change everything in a contract. Yes, we've just seen that you can put a right to make unilateral changes in the offer, but there have to be some limits. Otherwise, if I can change everything in my commitment, I don't have a commitment, right? That's what we were right about when we were thinking about Alice and Bob. Reaction is G. If Bob can just change anything, what commitment has Bob made? And that's right. Same with the bank. If the bank can just change everything, then they have no commitment. And if there's no commitment, there's no contract, because contracts are a commitment now by I commit, you commit, and there have to be some things we can't change. Otherwise, we have no contract. So the Purdue court notices, the Purdue court acknowledges this. They say, look, when one party has the discretionary power to change terms, there's a duty imposed on the one having the discretionary power, that's the bank in the case, to affect the rights of the other party to exercise that power in a manner consistent with the covenant of good faith and fair dealing. In a consumer contract, when are terms consistent with the covenant of good faith and fair dealing? When they're consistent with the consumer's reasonable expectations. And the test for reasonable expectations is the three-part test from Stephen. So when the bank acknowledges this, in the consumer situation, this is just another way of talking about being consistent with respecting consumers' reasonable expectations. So same requirement that we saw in Stephen, right? So to summarize, because we will need this later when we go to online contracting, can I have an updatable contract? Absolutely, I certainly can. I need to make sure that my power to make unilateral changes is in the offer that I make, but then I can do it subject to the limitation that I must be consistent with the other party's reasonable expectations about terms. I can't just change everything, right? In particular, I can't change the obligation to respect their reasonable expectations. That's an unchangeable obligation, right? Often referred to in this context as the covenant, the promise of good faith and fair dealing. That's an unchangeable obligation. I can't get rid of that one. So that's the limit. I can make changes within that limit, and we've seen within Stephen that can be a fairly powerful limit. So with this, we are ready to look at online contracting and the issues it raises. One of them being one of the critical ones being updatable contracts. So see you, as I say, in the next video.